So my question is, what is the legal significance of the fact that she took a separate asset, money from her 401k, and invested it in this company, gave it to her husband, and then her husband bought an interest in the property that was in his name only? But clearly, that interest in the property under Tennessee law would be considered to be marital property because it was acquired during the marriage.
Then in 2023, there was an additional opportunity for Mr. Blair to purchase an additional 9% interest in Parthenon Plumbing, which would require a payment of $18,668. On this occasion, they had the same agreement, but
She used her retirement money to build her husband's company. But after his death, the family turned against her in court. Then the judge snapped, "Wouldn't that be marital property?" And the entire courtroom went silent.
John David Blair versus Greta Louise Blair. All right. Then if you're ready, I'm ready. This is an exception to the amended claim. What?
Oh, you need the table? Okay. My office, I can tell. I'm being displaced from my office, Judge.
We have a claim filed by Greta Blair against the estate of John David Blair. And it's been an amended verified claim, and now that has been accepted to, if I understand correctly. But start it off by telling me who you are and who you represent.
I'll kick it off. Your Honor, Philip Irwin of the Nashville Bar, and Liz Clement and I represent the claimant, who is the surviving spouse of the decedent, Greta Blair. We're here today because of an interest that the decedent held, an ownership interest in Parthenon Plumbing. As the name would suggest, it's a plumbing company. Mr. and Mrs. Blair were married for 14 years before his untimely death in September of 2024. There are no children of this marriage, but there's one surviving daughter from a previous marriage, Mr. Blair's surviving daughter, and that's Caroline Crenshaw. At the time Mr. and Mrs. Blair were married, Mr. Blair worked for Parthenon Plumbing and Mrs. Blair worked for Raymond James, still works there. In 2021, an opportunity was presented to Mr. Blair to be able to buy into and become an owner of Parthenon Plumbing. And it would require a buy-in of $32,000. And like most people, they didn't just have $32,000 lying around. So they agreed between them that Mrs. Blair would borrow from her 401k the amount needed to purchase the ownership interest in Parthenon Plumbing for Mr. Blair, and she did so. And their agreement was that when the company began to issue dividends, that she would be paid back. That did not happen prior to his, as I said, his untimely death in 2024. So Mrs. Blair went ahead and borrowed the money and loaned it to Mr. Blair to invest in Parthenon Plumbing, yielding a 10% interest, Mr. Blair, in that company. You may be aware with 401ks, especially one sponsored by your employer, Raymond, or in this case, Raymond James, monthly deductions were made from paycheck until 2025, when By that time, Mr. Blair was deceased, and Mrs. Blair paid the remaining loan off with his life insurance proceeds, or a portion of his life insurance proceeds. Then in 2023, there was an additional opportunity for Mr. Blair to purchase an additional 9% interest in Parthenon Plumbing, which would require a payment of $18,668. On this occasion, they had the same agreement, but Mrs. Blair took a premature distribution because she had not reached 59 and a half years old. So she took a premature distribution of $26,073. And the reason it wasn't exactly 18,000 is because there was a little bit over $7,000 penalty owed to the IRS for liquidating a portion of her 401k. So she borrowed 26,000, or didn't borrow, she liquidated her account in the amount of about $26,073. So the total invested by Ms. Blair and loan to Mr. Blair was about $61,500. By the time Mr. Blair had passed away, the ownership interest had grown from the amount that Mrs. Blair invested in it to $198,500. There was a redemption agreement, and that money is now in the estate account and sitting there in the estate account. All Mrs. Blair is asking for here is a return of her investment in Parthenon Plumbing prior to the distribution of the remaining sum. And technically, there could be an equitable argument that she's owed all of it, because without her money, none of this would have ever been there. But all she's seeking is to get her initial investment back before the remainder of the money is divided among the surviving heirs. And that is what the proof, we believe, will show.
All right.
Good morning, Your Honor. Kristen Amonette of the Nashville Bar. May it please the court. Your Honor, I represent Caroline Blair Crenshaw in this matter. Miss Crenshaw is the only child of the decedent, John David Blair, and a beneficiary of his intestate estate, along with the petitioner and administratrix of the estate, Greta Blair, who was the decedent's wife. Your Honor, the decedent, John David Blair, he died unexpectedly on September 1st, 2024. And on January 27th, 2025, Miss Blair, so that's about almost 5 months later, his wife opened his estate for administration. And at the time of the filing of the petition to open the estate, Miss Blair asserted that the estate consisted of the marital residence, which was owned by tenants by the entirety, and some personal property in the amount of about $250,000. Because Mr. Blair died intestate, Miss Blair and Mrs. Crenshaw, by statute, TCA 312104, will share in the assets of the estate equally. There were 3 claims that were filed against the estate during the applicable claim period, Your Honor. One by Capital One for about $945, one by U.S. Bank for about $2,171, and a claim by Miss Blair in the amount of $51,500. Now, that was the initial claim, Your Honor, $51,500. That claim was later timely amended to also include a claim for interest and early withdrawal penalties for the 2 loans that Miss Blair alleges consisted of this $51,500. The estate filed an exception to the Capital One and U.S. Bank claims, and those were ultimately precluded. The estate did not file an exception to Miss Blair's claim, but on August 4th, 2025, Miss Crenshaw did timely file an exception to the claim. Thereafter, Miss Blair filed an amended claim, and Miss Crenshaw filed an amended exception. Those were all timely filed. The basis of Miss Blair's claim, Your Honor, against the estate consists of 2 alleged loans that she provided the decedent to purchase an interest in the plumbing company where he was employed. So that's Parthenon Plumbing, Heating, and Cooling, LLC. Miss Blair alleges that she provided the decedent a loan in the amount of $32,500 and a loan in the amount of $18,000 to purchase his interest, or this interest in Parthenon Plumbing. The $32,500 loan was provided on July 28, 2021 via a loan against her 401k. The $18,000 loan was allegedly provided on September 13th, 2023 via a cash out of an IRA in Miss Blair's name. Miss Crenshaw filed an exception to Miss Blair's claim because Ms. Blair did not provide any evidence of a writing documenting that the funds were a loan to Mr. Blair and that he committed to repay them. There was no promissory note provided, no loan agreement, nothing. In addition, Ms. Blair provided no evidence that the funds that she alleged she loaned the decedent were not repaid, either during the decedent's lifetime or after the decedent's death. In fact, in Ms. Blair's original claim filed with this court, she provides documentation of correspondence between herself and the president of Parthenon Plumbing that she is to receive $198,500 for Mr. Blair's ownership in the plumbing company. And as opposing counsel just testified, apparently she has received that money and it's in the estate. In and of itself, Your Honor, that's more than $50,500. Ms. Blair provides evidence in her amended claim that on July 31 of 2021, she took out a loan in the amount of $35,000 from her 401k. She provides documentation that on July 28, 2 days earlier of 2021, there was an electronic deposit into a checking account in the decedent's name from an account in her name in the amount of $32,500. The deposit is actually 2 days before the loan was originated. Now, there's no documentation that the funds deposited into the decedent's account are from the Raymond James 401k, or they're in fact a loan to the decedent, which he agreed to repay, or that the funds were never repaid by the decedent. No evidence, other than presumably Ms. Blair's testimony, which we'll discover as we proceed with this hearing. Ms. Blair provided documentation also in her amended claim that in 2023, she withdrew $26,073.36 from her IRA, and $7,822.01 were withheld, and that was the early withdrawal penalty. And then on 9/13/23, there is a deposit into a checking account in the decedent's name for $18,000 from an account in Ms. Blair's name. Again, though, there's no documentation that the funds deposited into the decedent's account are from this Raymond James IRA, that they're in fact a loan to the decedent, which he agreed to repay, or that the funds were never repaid by the decedent. In response to the request for production number 1 submitted by Ms. Crenshaw to Ms. Blair states there are no written promissory notes or loan agreements between claimant and her deceased husband. Tennessee law requires, Your Honor, pursuant to TCA 29-2101, that, and this is a quote, no action shall be brought upon any agreement or contract which is not to be performed within the space of 1 year from the making of the agreement or contract, unless the promise or agreement upon which such action shall be brought, or some memorandum or note thereof, shall be in writing and signed by the party to be charged therewith, or some other person lawfully authorized with such party. Your Honor, there's no evidence, and there's not going to be any evidence in this case here that there is a loan that is in writing. So there's no way to prove that there was a loan and that the loan had to be paid within a year. So the claim is going to be precluded on the basis that it's not in writing pursuant to statute. Your Honor, there's no documentation or evidence provided by Ms. Blair that any alleged loan to her husband has not been repaid. Her own bank records, which were subpoenaed by Ms. Blair's attorneys, her own bank records show deposits into her accounts exceeding $74,000 between 7/21, the date of the first loan, and Mr. Blair's date of death. And that is excluding her paycheck or any income tax refunds. Since Mr. Blair's death, Ms. Blair has received life insurance proceeds, one that I know of in the amount of $30,000, because that's in the bank records, a $19,000 income tax refund from the year of his death that was married filing jointly, his 401k proceeds, their home, and proceeds in the estimated amount of $198,000. Apparently that's in the estate. This is the first I've heard of it, but it's good to know. Ms. Crenshaw's position, Your Honor, is that Ms. Blair's claim is precluded by TCA 29-2101 because it's not in writing. 2, it's otherwise precluded and should be denied because she has no documentation admitted by her discovery responses reflecting a loan to Mr. Blair and an agreement to repay Mrs. Blair. Her own checking account records show deposits exceeding the loan amount during this relevant time period between the first loan and Mr. Blair's date of death. and she has received well in excess of the alleged undocumented loan amount of $50,500 since Mr. Blair's death. Thank you, Your Honor.
You may put on your proof.
Yeah, if I may please, if the issue is a purely a legal one, I think we can dispense with the testimony and go forward. If it's a statute of frauds defense, there's plenty of authority that statute of frauds does not apply in this case. And if that's the objection, then I think.
I think there were three objections. One of them was that one of the objections, if I understood it, was that it's precluded under 29-2-101 because it's not in writing. Another was that there was no proof that there was an agreement. There was no proof that there was an agreement between Mr. Blair and Mrs. Blair that her deposit of those funds constituted a loan that would be repaid. And then the third one was, I think, that she's received more than those loans amounts in other assets or out of the interest of that. Now, I don't mean to speak for counsel for Ms. Cleveland, but I think that was what I understood. I don't care how you wish to proceed, but if you want to address the argument about the statute of frauds, then you may do so.
Your Honor, I understood the first two arguments, the fact that it violates statute of frauds and that there's no writing. Well, the statute of frauds does require a writing, so I saw those as both an argument of the statute of frauds because she's saying that it wasn't reduced to writing, therefore it's violated of the statute of frauds. And I've got legal research here that I can hand the court and hand to counsel that this partial performance takes it outside the statute of frauds. And there's just no way that anybody takes $32,000 out of their account or then takes an $18,000 premature distribution unless there is some sort of agreement to do that. Certainly not when it goes directly into her husband's business in order for him to acquire an ownership interest in that. So part performance, I mean, we can argue that maybe in closing.
They were married at the time that this transaction took place, correct?
They were, but it was, the investment was in his name, but she put the investment into that for his.
And was the 401k or the money where she withdrew that, was that something that was acquired during the marriage and were marital funds by Tennessee law?
She already had that when she came into, I don't believe it would be because she already had that when she kind of came into the marriage. Now, obviously it grew during the marriage.
Right.
It was through her employer, so it did grow.
So the question would become, if she took a separate asset of hers and invested it into a company that they later acquired an interest in, even though it was held in his name under Tennessee law, wouldn't it be marital property? The company?
Wouldn't it be marital property?
Yes. I hear this all the time in divorce cases where you take, she's transmuted a separate asset by putting it into an asset that's acquired during the marriage. Marital property is all property acquired during the course of a marriage, unless it's acquired by separate, that it's separate property or that it is inherited property or something like that. So my question is, what is the legal significance of the fact that she took a separate asset, money from her 401k, and invested it in this company, gave it to her husband, and then her husband bought an interest in the property that was in his name only? But clearly, that interest in the property under Tennessee law would be considered to be marital property because it was acquired during the marriage. So that interest in that property, in that company, acquired through perhaps the use of her separate monies, was marital property. And then that marital property, upon his death, she inherited all of that. Is that correct?
She did not inherit it. She had it paid into the estate. So it's being held in the estate. I think you could make an argument that it is solely her property. We're not making that argument. All we're asking for today is that the money that basically all of this money came from, the original investment be paid back before the remaining money is split with Mrs. Crenshaw or with Ms. Crenshaw. So she's just asking for her investment in the company
Understood.
back before the rest of it's distributed. I think you could make an argument that it solely belongs to her, but as out of an abundance of caution, we had it deposited into the estate account so we could bring it before the court.
All right. You wish to respond? I mean, obviously, they're arguing part performance as being an exception or removing it from the statute of frauds. And I'll consider that at the appropriate time. But if you want to put on your proof, we'll let you do that.
We'll do that. And I'll provide the legal case, the legal authority upon which we rely. Look for consideration. We'll get to that after the testimony.
Good morning, Your Honor. Mary Liz Clemens of the Nashville Bar, representing Ms. Blair alongside Mr. Irwin. I'd like to call our client, Ms. Blair, to the stand.
All right, Ms. Blair, if you'll come around to the witness stand, please.
Thank you.
Step right around here. Be careful. You'll stand and raise your right hand and be placed under oath.
Good morning, Ms. Blair. Please state your name for the record.
Greta Louise Blair.
Say the first name again, just to
Greta Louise Blair.
make sure Madam Court Reporter heard that. And please state your address.
206 Hudson Drive, Gallatin, Tennessee.
Have you been married before?
No. I mean, not before John David.
Right, but
Yeah.
before in general, yeah. Okay, who are you married to?
John David Blair,
And how long were you all married?
14 years,
And you were together before you got married, how long?
about 10.
Did you and Mr. Blair have any children together?
No.
Did Mr. Blair have any other children?
Yes.
When did Mr. Blair pass away?
September 1st, 2024.
And what do you do for your career?
I work at Raymond James. I'm a sales assistant.
What did Mr. Blair do?
He worked at Parthenon Plumbing and was part owner.
When did he start working at Parthenon Plumbing?
I don't know the exact date.
An estimate is fine, just around.
I don't know.
Okay, well, we can deal with that later. What did he do at Parthenon Plumbing?
New construction.
And do you know whether Mr. Blair owned any part of Parthenon Plumbing at the time that you all got married?
No, he did not.
What was the date of your marriage?
October 9th, 2010.
And during your marriage, did Mr. Blair actually have an opportunity to buy into Parthenon Plumbing?
Yes.
Around what time did he first have that opportunity?
2021.
Did he have to make an investment to obtain ownership?
Did he have to make an investment?
To obtain an ownership interest in Parthenon?
Yes.
What was that amount?
32,500.
And did he have that amount to invest on his own?
No.
So do you know how he obtained the money to make that investment?
Yes.
How?
I took a loan from a 401k.
And who held your 401k?
Principal through Raymond James,
And how long have you had that 401k?
about 30 years.
Have you worked at Raymond James that entire time?
Correct.
Okay.
I'm sorry, how long did you say you had the 401?
30.
Your Honor, I'd like to pass up this to the witness. I'll give some copies. Done. Ms. Blair, have you seen this document before?
Yes.
What is it?
It's the contribution agreement between John David and Parthenon.
What's the date of this document?
July 30th, 2021.
Will you please turn with me to page 4?
Your Honor, I'm going to object to this document being hearsay unless we can lay a foundation for it.
Your Honor, we'd just like to enter this as for identification purposes. Right now, we do have a custodian of records affidavit in our subpoena, and we have the custodian of records from Parthenon actually here, and she'll testify later.
I'll admit it for the limited purposes of identification at this point in time and reserve your objection.
So Ms. Blair, if you'll turn to page 4. Do you recognize Mr. Blair's signature there?
Yes.
Okay. And please turn to the next page. Do you see Mr. Blair's name on this page?
Yes.
What does it indicate here that was his cash contribution
32,000,
and his percentage interest?
10%.
We're done with that document for now. You can put that to the side.
Mark this is where you begin to pay for you.
Your Honor, I'd next like to pass up a loan application and agreement. This was obtained from our subpoena to Raymond James. We have that custodian of affidavit record, although I believe we have an agreement to the authenticity with opposing counsel on that, but I can pass that to you if need be.
Is this the loan agreement with Raymond James?
Yes,
Do y'all have a business records affidavit? for
we
it?
do.
Can I see it? I don't have. No, hold on, Your Honor. No objection if they've got the business records affidavit. No objection, Your Honor.
All right, we'll mark these as a collective exhibit. You want to make us an exhibit?
Yes, Your Honor.
We'll mark the the affidavit of records custodian along with the loan application will be marked as exhibit 1.
Did I give you one already? Do you have this already? I don't remember if I
know.
handed it
I
to
don't-
you. There you go. Ms. Blair, do you recognize this document?
Yes.
What is it?
It is the loan agreement for my 401k.
And as we discussed here in court already, our office received this pursuant to a subpoena. Is that correct?
Yes.
Will you please read the first paragraph of this agreement, the first full paragraph?
I, Greta Blair, hereby apply for a loan from the account held for my benefit in the Raymond James Financial Incorporated 401k plan in the amount of 35,000. The loan will be repaid by me over 117 payments of $328.94 with a final payment of $328.92 by regular payroll deduction. I understand a one-time $75 setup fee will be deducted from the account the plan holds for my benefit.
Okay, now drop down to part 2A. If you'll read the first sentence beside promise to pay.
I promise to pay to the order of the trustees of the plan the principal sum of 35,000 plus interest of the unpaid balance at the rate of 4.25% per year until the loan is repaid in full.
Now flip with me to the last page. Did you sign this document?
Yes,
How did you sign it?
e-signature,
And what was the date?
7/6/21.
Done with that. Did you and Mr. Blair keep separate or joint bank accounts?
Separate.
Why?
It just worked out better for us that way.
Where do you conduct your banking?
Bank of America.
And throughout your entire marriage to Mr. Blair, did you always conduct your banking at Bank of America? I'm going to pass up some Bank of America records, same thing.
I do actually have a copy of the custodian of records for Bank of America, so no objection to those records.
Well,
Ms. Blair, you need a copy as well. Okay, we're gonna begin on Bates stamp BOA 00043, just so, I think that's what you're looking at, but Miss Amonette, if you need to get there.
What is it?
Bates stamp 0000403. There's a lot, so I just wanted to help orient everybody.
You're fine, go ahead.
Miss Blair, do you recognize this document?
Yes,
What is it?
my bank statement for July of 2021.
And your name appears at the top of this document?
Yes,
And what is the first big red heading that we see?
deposits and other additions.
And which account is this for you?
My checking,
And the third line down, what is the date of that highlighted transaction?
7/8 of 21.
And please read the description of that transaction.
Principal trust. The principal trust description, DRCR to Greta Blair,
And what is the amount?
35,000.
And again, what date is this?
7/8 of 21.
And so that's the date that you received that deposit from Raymond James.
Yes.
And principal is who?
That's who I have my 401k with.
Do you believe that this is a true and accurate copy of your bank statement?
Yes.
Your Honor, I'd like to make this formally the next exhibit. Exhibit number 2 is a collective.
Be marked as exhibit 2.
Ms. Blair, we're going to turn the page now. Bates stamp 0000404. Read the red heading at the top of this page.
Withdrawals and other subtractions.
Now go to the highlighted portion. What is the first date of the highlighted portion?
7/8 of 21.
Please read the description.
Banking transfer to savings 3884,
What is the amount?
33,000.
And the next line down, date,
7/8 of 21.
description,
Online banking payment to CRD 3922,
and amount.
2,000.
And what were these amounts for? What was happening here?
I was going to transfer these funds to John David for the purchase of his shares.
And we'll come back to this document, so put it aside just for now. Miss Blair, do you know who Mr. Blair banked with?
US Bank.
Did he bank with US Bank throughout your entire marriage to Mr.
I
Blair?
think so.
I do, yeah. This one's actually.
Miss Blair, do you recognize this document?
Yes.
What is it?
John David's bank statement for July of 21.
And you're familiar with are you familiar with his bank account number?
I see it.
We're gonna go to the first highlighted section. What heading does that appear under?
Deposits, credits,
What date does that occur?
July 28th.
And what does the description say?
Electronic deposit from Bank of America, Greta L. Blair,
In the amount of?
32,500.
And what does this reference?
This references the amount of the buy-in.
And what was the date of this bank statement?
July 21st through August 18th of 21.
Your Honor, I'd like to mark this as the next exhibit, collective exhibit number 3. And we're going to come back to both the US Bank and the Bank of America, so everyone hold on to those. Miss Blair, did you pay back the loan that you took out of your 401k?
I was paying it back monthly through payroll deduction.
And did you ever fully pay that off?
I did.
How?
I paid it off last year. The remaining balance proceeds that I got from his life insurance.
Your Honor, I'm going to pass up an exhibit now for demonstrative. Ms. Blair, what, if anything, does this show for the year of, or what is this document?
Total 2021 and 23 amounts for Parthenon investment.
And for 2021, what does it show?
A total of 37,163.72.
And 2022 in the chart on the first page.
Oh, 7,894.56.
And 2023,
Oh, 7,894.56.
2024,
7,894.56.
2025,
3,332.45.
and June 30th, 2025.
6,529.25.
And what does this chart represent?
The amount, the payoff of my loan.
And do you believe that this document is accurate?
Yes.
One moment. Your Honor, I'd like to mark this as the next exhibit,
No objection, Your Honor.
and we will come back to it. Ms. Blair, is this document based on an amortization payment schedule?
Yes.
And why did we do it that way?
Why do we do it that way?
Mhm.
So it could come out of my check monthly, make it easier for me to pay off.
And how much total was your actual investment to Mr. Blair?
For the 401k,
Mhm.
32,500,
And how much total did you take out in your loan?
32,500.
So for 2021, you're asking for a total reimbursement of how much?
37,163.72.
Okay, Ms. Blair, and does that represent the total amounts plus interest?
Yes.
Did Mr. Blair ever have another opportunity after 2021 to acquire another membership interest or greater membership interest in Parthenon?
Yes.
When?
And 2023.
Do you know how much that buy-in was?
18,000.
And did he have the money for that buy-in on his own?
No,
How was that contribution funded?
I took the money from my IRA.
And how did you take that? Was it a loan or was it something else?
I had to pay a penalty, but yeah, I depleted my IRA.
Gonna pass it or not? I apologize, the records are voluminous. I'm gonna pass this, so let's give you this one. There you go. I'll give you 2 copies. This is the Raymond James records as well. Ms. Blair, what is this document?
My IRA monthly statement for August and September of 23.
And Did you withdraw anything from this time?
Yes,
How much?
$26,073.36.
I'd like to make this the next exhibit, Your Honor. Believe we're on 4?
5.
5. Okay. These are the same Raymond James records, different excerpt. Ms. Blair, do you recognize this document?
Yes.
What is it?
Right, year-end, 2023 summary.
And what does it show under distribution summary?
A premature distribution of $26,073.36.
And does it show anything else?
Yes, federal withholding of $7,822.01.
So what was that?
That was the penalty I had to pay.
Now we're going to turn back to the Bank of America records. I'll find my copy in this. Will now be on Bank of America record Bates stamp 000395. Sure everybody's in the same place. Oh, actually, flip one more. 000213. These are the same Bank of America records from earlier, correct?
Yes.
And what does the red heading at the very top state?
Deposits and other additions,
And what is the highlighted date?
9/12/23.
What is the description?
Raymond James, description, Greta Blair,
And the amount?
18,251.35.
And the next page? What does this red heading read?
Withdrawals and other subtractions,
And then the highlighted portion, what is that date?
12/23.
And the description?
Transfer Greta L. Blair to.
After her husband suddenly died, a courtroom battle exploded over nearly $200,000 tied to his plumbing company. His wife claimed she used her own retirement money to help him buy into the business years earlier, but his daughter's attorney fought back hard, saying there was no written agreement and no proof the money was ever meant to be repaid. The tension instantly rose when the judge interrupted and questioned the entire argument, asking if the business was actually marital property all along. What started as a family investment turned into a brutal inheritance war in court. Comment for the next part.
John Blair,
And the amount.
18,000.
Now grab those US bank records. Last time. We're going to be on the second page, Bates stamp 000095. And these are the same US bank records from earlier, correct?
Yes,
And under the highlighted portion, what is that transaction date?
September 13th.
And the description?
Electronic deposit from Bank of America, Greta Blair,
And the amount.
18,000.